Good morning, ladies and gentlemen. Welcome back to Bexar County Court of Law number 6 in the Bexar County Veterans Treatment Court. Today is Wednesday, April 20, 2022, and we have our motion to revoke probation docket. On my docket today, I have cause number 629957, State of Texas versus Michael Riviezo, represented by Mr. Jonathan Ross. Mr. Ross with us at this time?
Your Honor, he has signed in, but he may be in another court at this point.
I understand. I have cause number 649023, State of Texas versus Marcus Creason, represented by Mr. Ron Funari. Mr. Funari, are you ready to proceed?
I'm not, Judge. I haven't gotten an offer from the state.
Okay, you understand there are no agreements on motion to revoke probation. Y'all can make any recommendation you want, obviously.
Yeah, he has a new number 1 case, though, and I wanted to hopefully speak to the DA about that. Sure,
we can do that. I have got number 665001, State of Texas versus Abel Gallegos, represented by Mr. Paul Acevedo. Mr. Acevedo, are you ready to proceed?
We are ready, Your Honor.
Thank you. I have cause number 671714, State of Texas versus Nicanor Vicuña, represented by Mr. Michael Collins. Mr. Collins, are you ready to proceed?
Your Honor, Mr. Collins was here. He has no contact with the defendant. He called the bonds people. At this point, I don't think they have either. He said if he did show up, he would come immediately, but he's just waiting.
All good, thank you. Cause number 663252, State of Texas versus Stephen Williams, represented by Mr. Andrew Froelich. Mr. Froelich, are you ready to proceed?
He has not signed in, Your Honor. I will text him.
Okay. And I have cause number 655959, State of Texas versus Michaela Grimaldo, represented by Mr. Orlando Castanon. Mr. Castanon, are you ready to proceed?
Yes, Judge, we are ready.
Thank you. And I have cause 646629, State of Texas versus Luis Martinez, represented by, I guess, Denora Diaz. Denora, are you ready to proceed?
Your Honor, she came in, but she was also in presiding, so she said she'd have to be coming in and out.
Okay. And I have 636502, State of Texas versus Mark Clark, represented by Ms. Valerie Headland. Ms. Headland, are you ready to proceed?
She is in a breakout room, I believe, talking to her client regarding the recommendations.
All right. Well, let's start with cause number 665001, State of Texas versus Abel Gallegos, represented by Mr. Paul Acevedo. And then we'll take up cause number 655959, State of Texas versus Michaela Grimaldo, represented by Mr. Orlando Castanon. Our ADAs for these matters are Eddie Villarreal and Arthur Reed. Our CSCD supervisors, Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Mr. Gallegos and Mr. Acevedo, the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Gallegos, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Acevedo, as attorney for Mr. Gallegos, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. In fact, Mr. Gallegos, is this your signature on this document also, sir?
Yes, sir.
And Mr. Acevedo, as attorney for Mr. Gallegos, is this also your signature on this document?
Yes, it is, Your Honor.
Once again, this is cause number 665001. This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Acevedo, my understanding is this is an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, it is, Your Honor. It will be a plea of true with an explanation.
Fair enough. Mr. Gallegos, in cause number 665001 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
True, sir.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Gallegos' probation? I remind you, you're still under oath.
Yes, Your Honor. His reporting has been good. We last saw him on April the 7th of 2022. We've not received any payments to date. He has a balance of $1,195 and is delinquent $133. We have no record of any of his 48 hours community service having been completed. He has, however, completed DWI education and victim impact panel, and we have no proof of enrollment or completion of the CATSNP program. He has one negative drug test on file. This is his first violation report, first MTR. He is currently blowing on the Smart Start mobile device 4 times per day. He has had 4 skips and 1 high BRAC, which occurred on March the 19th, March 19th, 2022. And it registered as a 0.048, and there was no retest to blow to clear. His officer is recommending that his Smart Start mobile device be increased to 6 times per day and that he be registered for all classes within 15 days. His criminal history includes arrests for assault, bodily injury, 2 possession of marijuana, 0 to 2 ounces, and of course, this instant offense.
And confirm Mr. Gallegos went on probation for obstruction of a highway on March 3rd, 2022. So he's only been on probation for a little over a month. Does that sound right?
Yes, Your Honor.
Okay. Mr. Acevedo, what are you requesting, please?
Your Honor, I would ask the court to consider the fact that he, since this incident with the high blow, he has taken the initiative to get certain things done. He has completed the DWI education class. He's completed the VIP program. He is registered for the CATSNP to start on April 23rd, which is this Saturday. He has been testing regularly with the pretrial services weekly, and he's been negative. The couple of missed blows that he did have, Your Honor, he blew just outside the window, and those blows were negative. So in all actuality, one of them was like just 1 minute outside the window, if I'm not mistaken. And the other one was like 20 minutes outside the window, and both were negative. He does have that one dirty blow, and he accepts responsibility for that. We'd ask the court to consider continuing him on probation and giving him the opportunity to fulfill this obligation to the court.
Hey, Mr. Gallegos, you got to stop drinking?
Yes, sir, I am.
Good answer, sir. State recommendation?
Your Honor, the state agrees with the probation's recommendation, but would add substantial compliance within 10 days.
Mr. Gallegos, in cause 665-001, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your deferred adjudication probation, or to continue on deferred adjudication probation with all prior requirements and no sanction at this time. Although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, sir.
Another good answer. Altering and amending your conditions, modifying your Smart Start mobile device from 4 blows a day to 6 blows a day. If you can show us a 30-day period of time at 6 blows a day without missing any blows and no high bracs for alcohol, I'll crank you back down to 4 blows a day. I won't know you've done that if you do it. You got to let your lawyer know. He'll let me know. I'll confirm it through probation, and we'll crank you back down to 4. I'm going to put you on weekly random UAs. Show me 4 clean weekly random UAs. I'll put you back on monthly UAs. Once again, if you do that, I won't know you've done it. Got to let your lawyer know. He'll let me know, and I'll confirm it with probation. I'm adding substantial compliance on all areas and all programs within 10 days. You don't necessarily have to start them in 10 days, but you got to be registered for everything you're supposed to be doing, which I guess is the Community Alliance for Traffic Safety New Intervention Program. Start doing community service hours, or you can donate $10 an hour to a court charity, which are primarily special operations wounded warrior organizations and family violence prevention organizations. You've already done DWI education, DWI victim impact panel. Good. But you need to get into the CATS program and work something out on your community service. And you need to start paying money. You're behind, but you're not far behind, so you can catch up. I'd borrow it from my rich lawyer if I were you, and I don't know any lawyers, Mr. Acevedo. Anything further from the state or the defense on Mr. Gallegos?
Nothing
From
further,
the
Your Honor.
state.
All right, from now on, Mr. Gallegos, you're not a fun guy. You're not partying with your buddies, right?
Yes, sir, I'm not.
All right. Y'all dismissed. Thank you very much. Susan, do you want to give them your spiel on probation stuff?
Yes, Mr. Gallegos, later today, you'll be receiving an email from me via Adobe Sign. It will be your alternate amended conditions. You need to sign those and return them immediately, okay? So be checking your email this afternoon. And then also touch base with Mr. Fonseca, let him know that you were in court this morning and that the judge did increase your blows and that you are to do weekly drug testing so that he can get you set up and provide you with those new times. Okay?
Yes, ma'am.
All right. Do you have any questions?
No, ma'am.
All right. Good luck to you, sir.
Thank you, guys. Bye-bye.
Okay, at this time, we'll take up clause 655-959, State of Texas versus Michaela Grimaldo, which is a first amended motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearings by Video Conference, which purports to have both Ms. Grimaldo's and Mr. Castellan's signature on it. In fact, Ms. Grimaldo, is this your signature on this document?
Yes, sir.
You and Mr. Castellan, as attorney for Ms. Grimaldo, is this also your signature on this document?
Yes, Judge.
Next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Ms. Grimaldo?
You're muted, Ms. Grimaldo.
Yes, sir.
And Mr. Castellan, as attorney for Ms. Grimaldo, is this also your signature on this document?
It is, Judge.
Mr. Castellan, my understanding is that this is going to be an uncontested first amended motion to revoke community supervision. Is that correct?
It is, Judge. She's going to be pleading true to the violations that's pled out in the first motion. The second, or the amended allegations, I believe we do have some information regarding issues with those testings. And I've also provided a test to a fast lab test to Mr. Virial, Mrs. Gross, and Mrs. Benavides to pass on to you. So we have explanation in regards to the allegations in the amended motion.
So is Ms. Grimaldo going to plead true with an explanation on
Yes, Judge.
amended motion to revoke community, and then she can certainly put any evidence or testimony on that she wishes to explain. Is that correct?
Yes, Judge.
All good. Ms. Grimaldo, on cause number 655-959 on the first amended motion to revoke community supervision, how do you plead, ma'am?
True.
Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Grimaldo's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Grimaldo has been reporting as directed. We last saw her on April the 12th, 2022. Her case is paid in full. We have no record of any of her 48 hours of community service having been completed, nor do we have record of completion or enrollment of DWI education, victim impact panel, or the CATSNP program. This is her first violation report, first MTR. She has no criminal history. She has had a total of one drug test where she has tested positive for marijuana at greater than 12,000, which is the maximum. She has had 6 high BRACs on the Smart Start mobile where she is testing it 4 times a day. And I apologize. She also has 9 skip tests. Her high BRACs were on March 20th, 2022, 0.075, March 18th, 2022, 0.090, March 27th, 2022, 0.026, April the 8th, 2022, 0.062, April 9th, 2022 at 0.023, and April 17th, 0.061. On 2 occasions, the defendant has admitted to alcohol consumption. Her officer is recommending a 30-day jail sanction, that she be placed on a SCRAM device, extended for a year, and be sent to SATA, followed by aftercare to assist with her alcohol problems.
Mr. Castellano, what are you requesting with regard to Ms. Grimaldo?
Yes, Judge. She does acknowledge the 2 BRACs of March 18th and March 20th. She indicated that she did drink on those days. She was dealing with a stress situation where her children were trying to be taken away by her baby's father. He didn't release the children back to her. She said she had self-medicated. She has, since the age of 5 to 14, undergone abuse. And as such, she has had issues, with dealing with alcohol. After the missed tests, she said she had been setting her alarms, but she would sleep through them. She did miss her test, but after I think the first motion before it was amended, she said she had corrected those issues. In regards to the breath tests on April 8th, if you look at the testing and according to the motion, in one of the testings, she had a 0.6 and a 0.06, and then it dropped in 7 minutes or 8 minutes to a 0.03. She did complain that there was issues with her mobile device. That same day, she went to go get a fast lab test done to show that she was not drinking. It was an 80-hour panel, she said, and as such, it came back negative. She also did go to Smart Start to see if they could recalibrate it or switch it out, and they said that they would notate it, but they don't calibrate those that equipment. And so she does complain that there has been an issue as of recently, but she does acknowledge it. She did drink on those first 2 days. She has a child that's 2 years old. She's a sole provider for, and I believe that she, is a good candidate to continue with probation. That a 30-day jail sanction and the ISF would cause significant interference with her raising her child. I would be asking that she does be put on a scram device, so that way you can monitor her. Issues with missing would not be an issue. We ask that you would hold the ISF and the 30-day jail sanction in advance. Additionally, she has, since this motion been filed, filed or registered for her classes. She is also attending an outpatient program, which she has been in attendance for. She did miss on Friday, but she has gone to 4 sessions. She did miss Friday, saying that she had to work late. She did call them and said that she would be, I guess, required to pay a $40 or $45 fine. And so we'd just be asked that, she'd be placed on zero tolerance and have scram added to her probation.
Ms. Grimaldo, a scram cam device, it's an ankle bracelet that monitors your alcohol consumption or not. 24 hours a day, it costs approximately $350 a month, is my understanding. Are you willing to pay that?
Yes.
Okay, and the probability is, I'm trying to be as candid and honest with you as I can. The probability is, under your circumstances, you're going to be wearing that Smart Start mobile until the end of your probation, which is in February of 2023, I guess. Does that sound right, Susan? Susan, am I right on the dates on this thing?
Yes, Your Honor, I'm sorry.
Yeah. So are you willing to do that, Ms. Grimaldo?
Yes, I am. So I will also have the blower and the scram device?
No, not at all. Once you have once you have the scram bracelet active, you can turn in the mobile device, the Smart Start mobile, which will save you $95 a month or whatever that is.
Right.
So,
okay.
Total for the scram device, in my understanding, and Susan, correct me if I'm wrong, it's approximately $350 a month. Does that sound right, Susan?
Yes, Your Honor.
But it's more fun than jail, isn't it right, Mr. Castanon?
Absolutely, Judge.
All right, state recommendation?
They recommend scram, weekly UAs, and substantial compliance within 10 days.
And Ms. Grimaldo, Mr. Castanon referenced that you apparently have started the Community Alliance for Traffic Safety New Intervention Program, which is our outpatient drug program. And you've already gone to what, 4 classes? Does that sound right?
Yes.
But you missed the class? That's more recently?
Yes, I missed it last Friday. I had to stay late for work.
Okay. I don't want to rain on your parade, but probation is more important than work, because work won't put you in jail, and probation and the court certainly can. Susan, if she's already done, no, she already missed one. So you've gone to 4 and you missed one. So technically you've had 5 classes and made 4 out of 5 in the outpatient program. Does that sound right, Ms. Grimaldo?
Yes, and then I start my VIP and DWI classes on the VIP class. I start on the 21st, which is tomorrow, and my DWI classes I start on the 24th.
Okay. Susan, in my opinion, Ms. Grimaldo has a very serious drinking problem. She knows she's going to be in trouble if she drinks, and she drinks anyway. So the textbook solution for us would be inpatient drug alcohol rehab. Plus, we also have 2 drugs, alcohol and marijuana, that we're dealing with.
That's correct.
That being said, because we don't really have a viable inpatient program in Bexar County right now, and that's not really an option for us, since it takes 2 months in jail before you ever get a bed in SATA. My question for you is, would it benefit Ms. Grimaldo, in your opinion, if we switch from standard Community Alliance for Traffic Safety New Intervention Program to the intensive outpatient program instead?
Yes, I believe she could benefit from that if you wanted to waive CAT-SNP.
Okay, but they cover basically the same things, I would assume, except the intensive is more intensive. Does that sound right?
Yes, it'll go more in depth and cover a wider variety of subjects.
Do you have any idea what the policy at the CAPS organization is for people that miss classes?
Generally, they have to pay a fine for missing, and then they are rescheduled to make up that class.
State, did I already ask your recommendation?
Yes, Your Honor. State's recommendation was scram weekly UAs and substantial compliance within 10 days.
And if I may, Judge, I believe that, intensive outpatient may be a good program. It would require her, I believe, to attend classes 2 days a week. If the CAT-SNP is providing substantially the same treatment, and if she's on a scram device, I think that would, obviously monitor very closely. And so I would ask that maybe she just continue on the CAT-SNP.
Here's my concern. Even intensive outpatient is still not enough for somebody that's showing the issues that Ms. Grimaldo is showing. She can't stop drinking. She's drinking way more than normal probationers would, even if they have a problem. So since I'm limited on my options, if I had an inpatient option, I'd be looking at that, but I don't. So that being said, instead of a jail term, I thought intensive outpatient, as recommended by Ms. Gross and CSCD, would be an option. In other words, she's going to have to start over. She's already done 4 classes in CATS. She gets credit for those, but she's not going to finish that course. I'm going to waive that course and put her in intensive outpatient, because we're dealing with 2 separate drugs and multiple violations, which is still more fun than jail. Do you agree?
I agree with that, Judge.
All right. And Ms. Grimaldo, are you willing to do all that?
Yes, I'm willing to.
All right, that's the plan. Ms. Grimaldo, on clause 655-959, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your probation. Order you continued on probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary?
No, sir.
Good answer. Altering and amending conditions, adding the Scram Cam ankle bracelet device within 10 days. As soon as that is active, you can turn in your Smart Start mobile device. Adding weekly UAs. Once you show me 4 clean weekly UAs, I'll put you back on monthly UAs. If you do that, I won't know you've done it. You got to let your attorney know. He'll let me know. I'll confirm it with probation and put you back on monthly. Substantial compliance in all areas within 10 days. Even if you don't start these programs, you need to be registered for them and know when that's coming. I'm going to waive the Community Alliance for Traffic Safety New Intervention Program and add the Community Alliance for Traffic Safety Intensive Outpatient Program. So you're going to be starting that one over, because the one you're in is not working, best I can tell. What did I miss? State?
I think that covers it all, Your Honor.
Defense? What I missed?
I think that's covers it, Judge.
Ms. Castanon, do you have any questions on any of this?
I think you meant Ms. Grimaldo.
I'm sorry, Ms. Grimaldo, do you have any questions on any of this?
No.
All right. That's all I got. Susan, do we have to do anything with regard to Ms. Grimaldo at this time?
Yes, Ms. Grimaldo, this afternoon, look for an email from me, Officer Gross, through Adobe Sign. It will be your amended conditions.
Okay.
Sign them and return them to me. I would touch base with Mr. Ovalle and let him know that you were in court today and what transpired. That way, he can get you set up on those weekly drug tests as soon as possible. What you're gonna do is you're gonna call a phone line and it'll tell you what days you have to go in and test.
Right.
And then the judge will sign your order for the Scram device, and it will probably not get sent over to Scram until tomorrow. So touch base
Okay.
with Scram and Mr. Ovalle, and he can give you the information on where you're going to get your Scram device from. Okay.
Okay, I did have a question because I know I'm doing the pre-trial also. What happens with all of that?
That's all going to go away. The judge is going to remove the warrant and all the pretrial conditions today. So you don't have to worry about them anymore. Now, once you get active on your Scram device, provide the proof that you are active to Mr. Ovalle. He will let me know. I will let the judge know. And we will send in a Smart Start mobile removal order for the judge to sign. It'll get sent to Smart Start. Then you'll be able to go and turn that in. Now, once you are actually strapped with the Scram, you can quit blowing into the Smart Start, okay?
Okay.
But it'll probably take a day or two after you get strapped before you can turn in the device.
Okay.
All right, good luck to you. Thank you, Judge.
Yeah, y'all are dismissed. Thank you.
Thank you, Judge. And if you would, if there was any warrants, if you would recall them, I think I
We're
did
gonna
notice.
recall all pretrial services, bond conditions, and warrants if there are any.
Thank you, Judge.
All right,
Have a
thank
good
you.
day.
Ms. Headland, are you ready to proceed on Mr. Clark's case?
Yes, we are. It will kind of depend, it's outcome determinative on whether we should have a contested MTR, I guess, but I would love to start and maybe reserve the ability.
Well, my understanding of the law is reference contested. This is a first amended motion to revoke community supervision. If you request what I call a fully contested motion to revoke community supervision, the only real difference between that and a normal one is we try to get the original supervision officer to testify. Ms. Gross, do you know who the original supervision officer for Mr. Clark is on this case?
Yes, it's Officer Wilcox, and she is in the office today as I have communicated with her. If you would like, I can contact her to see if she's available to come in.
That would be good.
All right.
And that's the first option. The second option is, obviously it's all coming to me anyway. You can plead true or not true on any of these conditions that you wish, and I'm the one that ultimately decides whether they're true or not anyway. The only really difference between a fully contested and a regular MTR in my mind is the fact that we have the actual probation officer that was supervising Mr. Clark testify. So if you'd like to have that, I'll have Ms. Gross look at that. And if we can't get her today, we can get her at some other time, and we're happy to do that.
I'm pretty sure, Your Honor, I am confident to argue for everything on behalf of Mr. Clark as an officer of the court and representing my client. However, there were violations that were sent to me this morning that I do believe are erroneous violations that I don't know if we need to get Ms. Wilcox involved, but that would be the only thing, is that I've been begging to get in front of you since January, Your Honor, for Mr. Clark, because he's had a warrant pending since December for this case, and you had already heard the MTR back in October. And so I'd like to get it resolved the easiest way possible, but if we're going to argue violations on the device, he was inpatient at Sam Rayburn or whatever it's called, Bonham Domiciliary, since those violations were to have occurred.
Well, that is exactly the reason in some of these cases we say true with an explanation or not true with an explanation, and he can go right down the line on all these conditions and say that one's true with an explanation or that one's not true with an explanation. And then when it's y'all's turn to testify capacity, you can just address each and every one as we go down the line if you'd like to do it that way. And if you want a what I call fully contested, Susan will make the call and see if that officer is available today. We can do it today, or if she's not available today, we can do it some other time. Or if you want to go without the original officer, you can still call it a contested, but it's not, we don't have the original officer there.
I don't think we need to don't think we need to put on evidence and delay it any further.
Judge, I contacted the officer and I believe she is signing in at this time.
Well, that's awesome.
Okay.
I mean, I can make it really quick, Your Honor.
No
Your
problem.
Honor, I just want to make sure.
All day, and this is Mr. Clark's life, and we're gonna take all the time we need. We're not in any hurry.
Yeah, Your Honor, as soon as she does sign in, Your Honor, I'll let her in. She just hasn't at this point.
Susan, I'm gonna have you just give us a general overview, and then we'll have the actual officer there, because I think there'll be.
She's coming in.
From Ms. Midland and the state on all that.
Miss Will is coming in right now, Your Honor.
What is the officer's name? I'm sorry.
The officer is Madison Wilcox, and I'll give my originating spiel and turn it over to her.
That'd be great. And I'm looking for Miss Wilcox. Do we have Miss Wilcox with us there?
Yes, Your Honor.
Hey, Miss Wilcox, would you please raise your right hand and I'll swear you in? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. This is cause 636-502, State of Texas versus Mark Clark. This is a first amended motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, that purports to have both Mr. Clark's signature and Ms. Headland, his attorney's signature on it. In fact, Mr. Clark, is this your signature on this document, sir?
Yes, sir.
Thank you. And Ms. Headland, as attorney for Mr. Clark, is this your signature on this document?
It is.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, let's see, which is supposed to be marked, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Pat, I have a blurry copy of this, but it doesn't look like it's marked. That's what's supposed to be marked. So administratively, please make sure that's marked on the original
Yes, sir.
document.
I'll look at it.
And Mr. Clark, is that your signature on this document also, sir?
Yes, sir.
And Ms. Headland, is this also your signature on this document as attorney for Mr. Clark?
It is.
Once again, this is a first amended motion to revoke community supervision. My understanding, Ms. Headland, is that this is going to be an uncontested first amended motion to revoke community supervision, but there may be conditions that Mr. Clark wants to plead not true to, and he's relying on me after testimony on both sides or evidence from both sides to make a decision on whether they're true or not. Is that correct?
Yes, sir.
All right. So, Mr. Clark, with regard to the first amended motion to revoke community supervision, how do you plead, sir?
Not guilty.
Not true.
Not true.
Okay, so none of these are true. Is that correct, Ms. Headland?
Well, I would say not true with explanation if you said that's one of my options.
It's one of your options, but you know, it just, I'm trying to cut to the chase. It just seems that if any of them are really true, then you need to plead true. If they're not true, fine, you can plead not true. But with all the different allegations of consuming alcoholic beverages, one would think one at least was true. But that's just me guessing.
Well, and that's why I'd like to kind of plead the case on this, Your Honor, and also ask Ms. Wilcox some questions on possibility.
Defense wants to enter a plea of not true to each and every condition, correct?
Well, on the amended, because the original MTR was the new number 1, which that case is pending. And then the number 21, that's above the first amended. I guess we could plead true with explanation on that one.
Is there a 21? I'm not even seeing a 21.
It's on the original part of the MTR page.
Oh, there it is. They would have been me. Okay. So do you just want to go down these conditions and then you can say true with an explanation or not true with an explanation? Or do you want to enter a plea of not true with an explanation to all of them? Which you have an absolute right to do if you wish.
Mr. Clark, do you want me to enter these on your behalf based off of our conversation earlier?
Yes, ma'am. Doing it
Okay.
not true.
We can go straight down, Your Honor.
Okay. And you want to plead not true to each and every one, or you want to listen to each one and then tell me what you want to plead?
Oh, not true.
My only problem is on number 21 on the first amended MTR that Susan sent me this morning at 9:04 is I don't know what the date range is for that number 21.
You know what? That's exactly right. Susan, shouldn't there be a date on condition 21?
Yes, Your Honor, there should be a date.
So I'm withholding my answer on that one. And that's the one that I would plead true with an explanation on.
I think the state can fix that. State, are you willing to move to withdraw violation of condition number 21 because it's defective in that it does not allege a date or a time period finite?
Yes, Judge.
All right, no objection from the defense, that will be granted. So there is no more violated condition number 21. So that one is not a problem.
So with regard to all of the rest of these, we would plead not true with explanation.
Okay, fair enough. Court accepts the plea of not true with an explanation to all the remaining conditions. So, Ms. Gross, would you please advise the court and the parties of the status of Mr. Clark's probation? And I remind you, you're still under oath.
Yes, Your Honor. Mr. Clark has been reporting as directed primarily by Zoom because he was in a residential facility out of the county. We last saw him on Zoom on April the 13th, 2022. His case is paid in full. His community service was probated for prior military service. He has also completed the DWI education and the victim impact panel. And the court waived the CATSNP program in lieu of him completing the residential program through the Veterans Administration. This is his second violation report, second MTR. He does have a new number 1 pending, which is a fail to stop and give information. His prior arrests include unlawful carrying of a weapon and a failure to stop and give info, which is pending. The officer is recommending that his probation be extended, that the court add a cognitive skills moral recognition therapy class through the CATS program, CATS IOP, that he be continued on Scram, yet not be given any credit for prior Scram use while he was in the residential treatment program. And as far as drug tests go, he's not had any. We have none on file. It's notated in our probation documentation system that the defendant was going to email the drug tests from the facility where he was at, and the officer would notify the court. However, I don't see anywhere that happened. And since he has been on Scram, he had 13 violations, many of which occurred while he was in the residential treatment facility. Apparently, while he was in the facility, he did not have the ability to download his Scram bracelet. So when he was discharged from that facility and finally got access to a place to download, which was in February, reports were sent to the probation department in February showing that he had these 13 alcohol violations. And from there, and explaining why the MTR wasn't filed until today, I'm going to have to turn it over to Ms. Wilcox.
Let me stop you there for a moment and clarify for all of us. He has allegedly 13 Scram CAM violations, and all those occurred while he was in an inpatient Veterans Administration program. Is that correct?
According to the best records that I can derive from the documentation that is in the computer system that we utilize to keep track of our records. Yes, Your Honor.
All right. And then when we call it a Scram CAM violation, does that mean it's a positive for alcohol, or what does that mean?
It could be either that he tampered with the device or that there was alcohol present.
So there's no testimony on, and we'll talk to the other probation officer shortly, Ms. Wilcox. We don't have any proof from the records of the Scram CAM organization that say they were positive for alcohol on these 13 alleged violations while he was inpatient. at the VA?
I'm going to defer that question to the officer, Ms. Wilcox.
Ms. Wilcox, can you answer that for us, please, ma'am?
If there were reported violations on the Scram device, was that the question?
Well, I want to know what the violations were. Does that mean that that the Scram Cam detected alcohol 13 times while he was in inpatient?
Okay.
Which I'm finding hard to believe that he had access to alcohol in the inpatient facility.
According to the reports I got from Recovery Monitoring, which is the agency we use for the Scram device, there were one second, let me count them here. There were 8 violations for TAC, which is the transdermal alcohol concentration. That would be the alcohol violations. And there are 3 violations for confirmed tampers, all between November of 2021 and January of 2022, which was when he was in the residential facility.
So 8 of those violations were supposedly positive for alcohol. Does that sound right?
According to the report from the monitoring agency, yes.
Hey, Mr. Clark, if you would, where did you go to an inpatient program with the VA?
Sir, I was at Sam Rayburn in Bynum, Texas.
And is that inpatient where you walk in the door and they lock it behind you and you can't leave?
Sir, yes, sir. I was allowed to walk on the campus, but I was not allowed to leave the campus, sir. And I can attest to you, sir, that I did not consume any alcohol and I did not tamper with the device. I don't see why I would drink alcohol and tamper with the device while I was in rehab and not do it when I'm out rehab.
What was if you recall, the exact name of this program or this inpatient alcohol drug rehabilitation program that you completed with the VA?
Your Honor, I have, if you'll allow me to screen share, I have his completion certificates and everything else too, and you can see.
What is the name of the course, Val?
It's called, he finished early phase program for substance use. He did 4 months of that last year, and then he finished it on January 5th, 2022. It's called Bonham Domiciliary, I can never pronounce that, early phase program. So he completed phase 1.
But
and
it is run by the United States.
It's at the Sam Rayburn and VA North Texas Healthcare System. So, and I have the certificate. I can show you if I can.
Veterans Administration on there anywhere, or is it some other program?
Yes. Yeah.
Okay.
And probation has a copy of that as well, Your Honor.
And it shows even Mark Clark, distinguished veteran, on it.
Does it show that Mr. Clark was in an inpatient program? I'm not familiar with any VA inpatient program where they can't just walk down the street and go to the ice house and get a Coke or something. None of them are locked down that I'm aware of. But Mr. Clark's telling me this one was locked down. Is that correct, Mr. Clark?
Sir, it's not locked down, but you are expelled if.
Okay, but you sleep there every night.
Yes, sir. There every week.
All right, I got it.
I have additional information too that I can share whenever it's our turn on that.
But for the record that we're looking at it, basically he spent 4 months, and I'm going to call it semi lockdown or whatever. He was at a facility where he spent the night there every night and went to classes every day. Does that sound right, Mr. Clark?
Yes, sir, I did.
He was under constant VA supervision, and he may have had some opportunities to go off campus, but they were all authorized. Does that sound right, Mr. Clark?
No, sir. You are not allowed to leave campus. And if you're in the early phase, you're not allowed to leave campus. If you're in the late phase, you're allowed to leave campus every other Sunday with a chaperone and only to go to Walmart. But I was not able to start the late phase because I had to start over with the early phase. While I was at Bonham VA facility, I never left the facility and I never had any consumption of alcohol. And I also have my drug test there. My lawyer and the probation officer, I passed every one of them. I never had any substance. I can tell you that, Your Honor. I went to rehab, didn't get it right the first time. I went the second time. We put me on medication. I can't see how this is happening. I would not waste your time, Your Honor.
No, I understand. What date did you graduate from this program, Mr. Clark?
The certificate says the graduation was January 5th, and I left that Monday after that.
Okay. And Ms. Gross, was he still on a Scram Cam device at that time?
He's still on a Scram device, Your Honor.
All right. And it's reporting and we haven't had any violations since
No,
January 2022?
No, Your Honor, it's not reporting. Ms. Gross advised me this morning that he was terminated from the program on March 31st, which Mr. Clark, because of bills, that's been the problem. So I don't know if it was a financial responsibility issue. And Ms. Wilcox, Mr. Clark has been communicating with Ms. Wilcox on all of that to try to keep me informed and his probation officer informed of his status, but he still has the device on his leg.
He graduated from the VA inpatient program on January 5th, 2022. We all agree?
Yes.
And he was still active on the Smart Start mobile, the Scram Cam device between January 5th, 2022 and March 31st, 2022. Is that correct?
Yes.
And we have no violations, Ms. Gross, between January 5th, 2022 and March 31st, 2022?
Let me double check the dates.
There's one on January 7th, but I believe he did not leave until the Monday after the graduation.
Okay.
So I think he was still on campus on that January 7th date.
Yes.
Okay, so can anybody give me an answer to that question? Was Mr. Clark still active on the Scram device between January 5th or 6th, 2022 and March 31, 2022?
Yes.
And there are no violations reported during that time?
On January 7th, there are violations reported.
Is that just one time during that time frame?
He had a confirmed tamper on January the 7th at 12:25 to 10:37 the next morning. And then he had an alcohol consumption also on January 7th from 1:10 p.m. to 10:08 p.m.
I'm looking for that on this MTR.
It's about the middle of page 2 on the amended.
November, January 7th, 22, 1:10 p.m. to 10:08 p.m. Is that correct?
Yes, that would be the alcohol consumption. And then the one below that one recorded that the device was tampered with from January 7th, 12:25 p.m. to January 8th at 10:37 p.m.
All right. Mr. Clark, is it your testimony that you did not consume alcohol on January 7th, 2022, and this is a false report of some kind?
Yes, sir. And I think I might know what was going on. I remember contacting my lawyer because there was some physical exercises that I wanted to be doing, and we tried to get in contact with you because they said that I would have to get the Scram device, but we wasn't able to get in contact with you because I wanted to start the physical education program. I don't know if with me working out and overworking if that's the reason why the tamper situation is coming out. Now with the alcohol consumption or whatever like that, I don't know if it was something in my blood and it sweated out, because that sounds like the times of the day that I will be at the gym, because we go through class all day and we work out late at night or we work out in the morning. I don't know if I hit it or something, or if I'm hitting it too hard, or maybe if I'm staying in the shower too long, that will cause the tamper. But I wouldn't.
I'm not worried about the tamper. I'm just worried about alcohol consumption.
Oh, no, because I was not allowed to. I mean, okay, I'm not going to lie to you. If I wanted to, I could walk off post, go get alcohol and come back on post, but I would be caught and I would be facing eviction from the program.
On January 7th, 2022, you don't have a recollection of being around alcohol in any capacity?
No, still in the program.
I got you.
Everything I did, and that's why I say I can't understand why would I do it in the program and not do it.
All right, let me ask you some personal questions with Ms. Headland's permission, and I'll ask them first and don't answer right away. So Ms. Headland said it's okay. Back when you were drinking, which is like a year ago, what was your drink of choice? Was it beer? Was it scotch? What was it?
You can answer that.
My drink of choice was pretty much Hennessy and beer. But I mean, I would drink anything I could possibly get my hands on. It didn't matter to me.
I got you. Thank you for that. That answers my question. Okay. just give me a minute. Let me run down all these violations and see if I've got any other surgical strike questions for anybody. And Ms. Gross, I'm looking at on the first page of the first amended motion to revoke community supervision. And there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 allegations, excuse me, of consuming alcoholic beverages starting on or about January 7th, 2022. And then it backs up and goes to December 23rd, 22nd, 21st of December 2021 and November of 2021, the 18th, the 17th, the 16th, the 15th, the 14th, the 13th, the 12th, the 11th, and the 10th. Those all are Scram violations. Ms. Gross, do you know?
Yes, these all occurred while he was on Scram, but they were not downloaded until he exited the facility in late February, at which time the officer was emailed the reports.
Okay, and Mr. Clark, I know you graduated on or about January 5th, 2022 from the VA inpatient program. What date did you start that program? It was probably 4 months earlier or something like that, correct?
Yeah. I remember I got out of jail around October 30th, and I remember I saw my family for Halloween, and we checked in that first Wednesday, I believe, if I'm not sure. I know I talked to my lawyer and my probation officer because we were supposed to go to start taking the drug tests that Friday, but she told me she would waive the drug tests that Friday because I was going into treatment that Wednesday. And I think that my lawyer and my probation officer can confirm that I was in there the first Wednesday of November.
So plus or minus November 5th, 2021 through January 5th, 2022. Does that sound right?
A little bit
So
after.
that the admission was actually November 18th, 2021. If somebody else has something different, like.
So November 18th, 2021, it started, and January 5th, 2022, it ended, plus or minus. That sound right?
Plus or minus. Yes, that's the day I graduated. That's the day it says.
That's his graduation date, Your Honor, but he wasn't discharged from the facility until February 2022.
So the total amount of time that he was in the inpatient program between 11/18/21 and 1/5/22 is going to be what, about 6 weeks, plus or minus? 11/18, you still got another week and a half or something on that calendar. Then you got the entire month of December, and then you're out the first week of January. Does that sound right?
Yeah, week of January.
4, 5, 6 to 8 weeks is kind of what I'm getting.
Yeah.
That's right, Ms. Hedlund?
Yes.
Okay, continuing saga. Mr. Clark, what are you doing now? We haven't had any violations on you. Are you still going to counseling at the VA, or are you completely done with that? Or what is it you're doing to help you stay away from alcohol?
No, sir. I'm taking venlafaxine. It's an antidepressant to help calm my emotions, and I'm also taking the Traxone. It's for alcohol dependency, and I take 1 tablet of that every day, and it helps me control my cravings. Okay. At the time, I'm not able to get out the house due to the warrant, so I just been homebound. But I've been doing a lot of alt work and just trying to keep myself busy because that's what I was doing, painting and stuff inside.
In a perfect world, if you don't have any warrants and you don't have anybody else bothering you, what kind of job do you want to get, or do you already have?
Actually, I'm a business owner, sir. I own tattoo shop, Tats and Tees San Antonio.
Ah, okay.
I would really like to get back into my business. This month has been kind of hard. My son had to move to Mississippi with his family. So hopefully next school year, if I don't have this lingering over my head, I can get him back, because she used to drop him off to the shop, after school. She don't feel comfortable with doing that because I have a warrant. So hopefully I can just, get back with my life and get back on track and get back to work, sir.
Okay, I got it. Let's do this at this time, if it's okay with Ms. Hedlund and the state. Let's ask Ms. or state. Let's start with you. Do you have any questions for Ms. Wilcox with regard to Mr. Clark's probation?
Not at this time, Your Honor.
Ms. Hedlund, do you have any questions for Ms. Wilcox with regard to Mr. Clark's probation?
I do.
Sure, proceed.
If you'll indulge me. Officer Wilcox, is it deputy or officer?
Officer.
Officer Wilcox, has Mr. Clark been checking in with you regularly
Yes.
throughout his probation?
Yes. While I'm his officer.
Have you always been his probation officer? Or when were you assigned to Mr. Clark?
I was assigned when I believe he was being seen out of county for a while. So when he was transferred back in November of 2021, I was assigned his case.
Okay, so basically from the time that he's been in Sam Rayburn Hospital, you've been his probation officer at least, correct? Okay. Has Mr. Clark communicated with you regarding any violations? Or have you, let me rephrase that. Have you communicated any violations to Mr. Clark?
In regards to the scram only?
Yes. Yeah, let's limit it to the scram device.
I do not believe I spoke with him about the violations that I received recently.
Okay. When did you first receive the violations that are being alleged this morning?
The report was emailed in early February. I don't have the exact date.
Okay. Did Mr. Clark send you any drug tests or urinalysis from Bonham?
I did receive an email with some document, like pictures of some drug testing results. They are cut off and not the full paper, so I could not distinguish what date went with what result, and from there I could not tell which test was with what result.
Okay. And is it true that Mr. Clark contacted you in December regarding the fact that he needed to have an MRI done and couldn't do that because of the device?
I do not recall that.
So you didn't put in a removal request in December of 2021 with the court?
No.
Okay. Have you had any communication with his inpatient through the VA? Have you received anything other than from Mr. Clark?
I have emailed with them about getting the information directly from them. However, they couldn't get the authorization to release the information to me. Therefore, no email after that was sent to me.
Okay. Is it possible, are you aware that the scram device was offline during the months that he was at the VA hospital?
I was aware of that, yes.
And is it possible that by reactivating it when he could reconnect, that it would fire misinformation or false violations?
I don't have enough information about the workings of the device to answer that question.
Okay. How many clients do you have on the scram device currently that you oversee?
Currently, I believe I have 3.
Okay. Is it possible, can you explain to the court how somebody would violate for hours at a time on the scram device? Because I'm confused by that as well. So for example, the violations say that he had alcohol concentrations from 1 p.m. until 10:08 p.m. So can you explain how someone has alcohol concentration for 9, 10 hours at a time?
When I receive the report, they have the TAC reading from every, I don't know what to call it except for like a push through. The results get pushed through to the download. And from the time on the violation report or the motion to revoke, the amended motion to revoke, from the start time to the end time, there were the TAC readings on the device from that start time to the end time.
So, but the interpretation of that, because you have 3 clients that are on that, does that mean that someone would be consuming alcohol for those 10 hours per se?
Depending on the readings exactly, it could be that someone had alcohol and then it was coming out of their system. So it was going, like the numbers were going down, the readings were going down.
How frequently is it reading for somebody when you have a device connected?
It reads approximately every 30 minutes.
Okay. So if somebody had daily violations, as indicated here on the days, one after the other for this amount, an extended period of time, would it be obvious that somebody was intoxicated and consuming alcohol during those times?
You mean,
in your opinion?
According, like just looking
well, this
at,
has 13 violations, correct, that we see? And I believe Officer Gross said there was 8 transdermal violations. And based on the report, it shows for extended hours at a time. If, in your opinion or your experience, is it possible for someone to have repeated daily scram alcohol concentration violations for hours at a time and not show any indication of alcohol consumption?
in my dealing with it, extended period of time of alcohol consumption on the report would mean alcohol consumption in real life.
Okay. That's all I have, Your Honor.
Hey, do you have any further questions?
Yes, Judge, I do. Officer Wilcox, you mentioned that you received these violations back in February. And these violations, you received them in February because they were just uploaded at that time.
Correct.
Now, can you tell us what happened between the time that you received the violation and why it was reported not until recently?
The motion to the original motion to revoke was pending. I was notified there. I'm trying to think of what the reports were given to me in February, emailed to me from the facility in February. The court officer emailed me yesterday saying that the court was happening this morning, and when I was reviewing the case, noticed that the violations needed to be amended on the amended motion to revoke. There is no specific reason that it didn't happen.
Okay.
Yeah.
And so why were these violations reported in February as opposed to earlier than that, if they occurred earlier than that?
Because he wasn't downloading the device daily. It's you have to download on the device. It pushes the results to recovery monitoring, and then that's how they make their reports.
And so even though it is not reporting these violations, or it's not reporting what it's recording, it is recording though, the device is. It's recording, but it could be recording alcohol consumption.
Yes, according to the report I received, yes, it was recording it the whole time.
Okay. And so it did in fact report some violations, right? During, prior to February, prior to receiving this download?
Yes.
Okay. In fact, there was 8 violations of transdermal alcohol concentration, correct?
8 sounds correct, yes.
8, okay. And so a transdermal alcohol concentration violation, that means that alcohol was consumed.
Alcohol was detected on the device.
On the device.
Usually alcohol consumption.
And so alcohol consumption or alcohol was detected on January 7th of 2022.
Yes.
Another transdermal alcohol concentration violation or alcohol was detected also on 12/23 of 2021.
Correct.
There was also another transdermal alcohol concentration violation on December 23rd of 21.
Correct.
another transdermal alcohol concentration violation occurred on December 21st, 2021.
Correct.
There was a second violation that occurred on that same day, December 21st, 2021.
Yes.
A third violation on December 21st, 2021.
Yes.
And a fourth violation on that same day, December 21, 2021.
Yes.
Now, the device also records when someone attempts to tamper with the device. Is that correct?
Correct.
And so that was also reported when you, that was also included in the report when you received it in February.
Correct.
Now, I think I missed one transdermal alcohol concentration. Another occurred in November, on November 10th of 2021 as well. Is that correct?
Yes.
Now, can you inform the court of how many tampering violations were reported in that report that you received in February?
There were 3 tamper violations.
Okay. And so these, just because it wasn't reported until February does not mean that these violations that were alleged in the report you received, it doesn't mean that didn't occur.
There is no reason for me to believe that, according to the report.
Okay. No further questions at this time, Your Honor. We'll pass the witness.
Do you have any further questions for Ms. Wilcox?
No, I'll just reserve for argument.
I'm getting background noise. Ms. Wilcox, I'm confused as to why these February violations were not reported in February of 2022. I think you said they weren't downloaded or something. You didn't have access to them, or what was the problem?
The reports from November to February weren't downloaded because the probationer wasn't downloading them. However, when I received the report in February, it got not missed, but I did not file the amended MTR in a timely manner.
Okay, so are you saying, obviously you're a representative of the probation department, that you made a mistake and just didn't report it timely? That's correct?
I overlooked the report and did not report, I did not complete the amended MTR. Correct.
Okay. Any questions based on mine? Ms. Hedlund?
No, I don't believe so.
State?
No, Judge, none from the state.
May this witness be excused, Ms. Hedlund?
Yes.
And state okay with you?
Yes, Judge.
Thank you, Ms. Wilcox. We appreciate your testimony. You're excused.
Thank you.
The last issue, I've got the rest of this figured out, Ms. Hedlund. The last issue I'm looking at is this allegation of a failure to stop and give information. Has
Yes,
that been resolved, or is that still pending? Do you represent him on it? What's going on with
Yes, I represent him on that. And if you would indulge me a quick minute, when we had the MTR, the first MTR that we actually had a hearing was on October 27th, Your Honor.
Yeah.
That case was already pending. However, it was not included as a new number 1 on the MTR at the time. Megan Galloway was the ADA at the time. And I remember distinctly you said, based on everything in the background and the explanation of what had happened, you asked Ms. Galloway to give me an offer on the new number 1. And we extended Mr. Clark another 6 months because of that. And because of the prior violations. However, it was not included on the physical motion to revoke document. So then what happened is in December, Mr. Clark became aware that he had a warrant for the MTR. I had no idea that he had a warrant. I thought the MTR had been resolved. We extended him for 6 months. We dealt with it. I thought we addressed it. We moved on. But then it was with Ross. Ross had signed the MTR from December. From that point to today, I've been begging and begging to try to get this resolved, to get the warrant released, because that case is set on your docket, Your Honor. We'll deal with that separately. But I think, to be honest, I think it was just a bad timing thing, because the case was filed on October 19th. We had the MTR on October 27th. We addressed it verbally and in the hearing, but it was not an actual physical part. So then Mr. Clark got caught up in the fact that a new MTR was filed for that same allegation from December. And we've been dealing with this fallout ever since, while Mr. Clark has been in the Sam Rayburn Bonham VA hospital.
And I'm sorry, go ahead.
May I provide some enlightenment?
Sure, enlighten us.
In regards to this new offense and us being aware of it and taking care of it, the prior officer, Ms. Calvillo, on November the 2nd, she sent you a supplemental report and advised you that a new #1 arrest had occurred for the offense of failure to stop and give information over 200, and that, you know, it hadn't yet been addressed with the court, and it was advised that an MTR be filed if and when the information is filed on the new case, because at the time of the supplemental report, there was no information. And therefore, that's why the new #1 wasn't filed on, which is the new offense that he has pending today, until December the 10th, 2021. Now, the information did come down prior to that. Why it was not filed in a more timely manner, that I can't answer. I'm not the officer of record.
Okay, Ms. Helen, I have one more question for Mr. Clark, and then I've got a plan. Mr. Clark, what'd you do in the military, sir?
You're muted, Lev.
Your microphone's turned off, sir.
Sir, I was a motor transport operator and a 50 cal gunner.
And did you go to Iraq or Afghanistan?
Yes, sir. I served in Operation Enduring Freedom. I was stationed in Kuwait for 3 months, and then I was stationed in El Takalim, Al Assad.
And Your Honor, I would like to just remind the court, Mr. Clark had a battle buddy that he observed being burned to death in the field. He is 100% disabled with PTSD. He has been found disabled also because of his alcohol addiction. And he is also on, which, you know, if you wanted me to question him, I could ask him, but he's also prescribed naltrexone, which is a anti-alcohol type of, it's not the same as the Antabuse. Thank you. My brain just left, but it is an addiction along with antidepressants. And I did explain all that to the court the last time, and I hate to drag Mr. Clark through that, but I'll reserve my final arguments for how to handle this case, if you would allow me to.
Let's ask you right now. What are you requesting, Ms. Hedlund?
Okay, Your Honor, I'm going to give you my spiel. So because of the horrible situation that Mr. Clark's been in, I don't know if the court can see all my papers on my desk, but I've dealt with Mr. Clark. Mr. Clark is a wonderful human being, Your Honor, and he suffered a lot at the hands and sacrificed a lot for our country. But I'm going to put the mushy stuff to the side and talk about his case. So as far as this case goes, Your Honor, he was put on probation in November of 2020 for 6 months. He's been extended for 6 months. He will have been on probation for over a year and a half at the time that he's supposed to terminate next month on May 11th. Because he was extended and you allowed him to go back to his inpatient treatment at Sam Rayburn back in October, he did that. He completed it successfully. He can't re-enroll in the second phase of this program because of the warrant and everything else. As far as the alcohol positives in the tampering. There's a problem with the Wi-Fi while he's inpatient. He's supposed to be going along with the program, and the fact that it didn't download until all at once and did a big, huge dump in February when he could reconnect, I do not want to give any credence to the fact that these readings are correct. A lot of them, if you've probably looked at them while we were gabbing along, some of them are 5:41 a.m. to 6:43 a.m. That's very random. Some of these are 2:04 a.m. to 3:36 a.m. I mean, Mr. Clark would have to be very deceptive and sneak out of Bonham domiciliary, Sam Rayburn VA Hospital. He's been in there twice. He did admit to this court the last time he was here that he did relapse in September, October of last year, but he readmitted himself. Your Honor allowed him to go back to inpatient treatment. He successfully completed that. I have his completion certificates. I think he's kind of been caught up in this nightmare, and he's done so much punishment for this one case. I would like to ask the court to give him consideration that he's been on Scram for over 5 months. That's at least $1,500 he's paid. He was on the PAM device for a year. That's another almost $1,200. He's fully paid in fines and fees, another $1,200. So, Your Honor, if I give him credit for all that, plus the bond he had to pay to get out of jail originally, Mr. Clark's paid over $4,000 in restitution, fines, fees, devices over the past year and a half. He spent 12 days in jail for this DWI offense. That's a Class B misdemeanor for an original 6-month term. I would ask this court to give all consideration to Mr. Clark's efforts. The fact that I don't believe that these violations that I just received this morning are legitimate violations. I would ask the court to withdraw the recall the warrant, release Mr. Clark from the Scram device, and allow him to terminate as natural. He's already been adjudicated also, Your Honor. He is not on deferred. So he's already been convicted of this offense, and he's set to terminate on May 11th. And I would ask this court to allow Mr. Clark to move on with his life. Let us deal with the last pending case and get this DWI behind us. Thank
State
you.
recommendation. I'm sorry. Do you have anything further, Ms. Hedlund?
No, thank you, sir.
State recommendation.
Yes, Judge, the state recommends revocation based on what we heard from Officer Wilcox, who told us about these violations that are alleged in the MTR, and the fact that they were uploaded in February, but there is also no evidence to suggest that just because they were uploaded at a later time than when they occurred, that they did not occur. And so the state is adamant that, these violations occurred, and we would ask this court to revoke this probation at this time.
Mr. Clark, in cause 636502 on the first amended motion to revoke community supervision, the court accepts your plea of not true to all with an explanation. I find that allegations of consuming alcohol and the new offense are true. Back in 2021, I also find that Mr. Clark has done an exemplary job of trying to correct his situation and avoid the use of alcohol in the last 6 months. I'm going to grant the state's motion to revoke Mr. Clark's probation in the nicest possible way. I'm going to put Mr. Clark in jail for 30 days and assess a $300 fine plus court cost, credit for time served, time and money to run concurrent. Judgment satisfied. So he does not need to go to jail. I commend Mr. Clark for his service to his country in the military, as well as being proactive in his rehabilitation. And I take specific note that the Bexar County CSCD and Ms. Wilcox were totally negligent in their alleged supervision of Mr. Clark, and probably caused Mr. Clark plus or minus 6 months to a year worth of extra time on probation that we could have avoided. So that will be taken care of on our side. And I apologize to Mr. Clark that happened to him. Anything further from the state or the defense on Mr. Clark?
Nothing from the state, Judge.
No, Your Honor. Thank you so much.
Is that okay with you?
That is totally fine, but I think Mr. Clark got panicked there. So if you wouldn't mind letting me explain it to him in a breakout room.
Yeah.
He thinks he's going to jail.
Of course,
Sir?
let me put you in a breakout room right now. Ms.
You're not going to jail. The
Hold
case is
on.
over.
Oh, I thought I had to
Okay,
go for.
I'm holding on.
Okay.
Hey,
All
let's
right.
put Ms. Edelin and Mr. Clark in a breakout room. 'Cause Mr. Clark's happy now.
Miss Gross has something.
Yeah, I got to give him some instructions. Mr. Clark,
Yes, ma'am.
effective immediately, your case is done, okay?
Thank you, ma'am.
A scram removal order will be completed today. It's probably not going to get over to scram until tomorrow, okay?
Yes, ma'am.
So why don't you call Miss Wilcox tomorrow afternoon to make sure that she's received the document and forwarded it over to Recovery Healthcare. And as long as she has done that, then you can proceed over there to get it removed, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you, ma'am.
You have a GPS bracelet on also, Mr. Clark?
I'm not sure, sir. I know
think it's just scram.
on the train. I don't know if it checks the GPS or not.
All right, well, but basically, we're recalling all pretrial bond conditions and warrants. And everything that you were required to do at this point, Mr. Clark, is over. You don't have to stay at home. You don't have to do that. You do whatever you want. And I suggest that keep in counseling or in contact with the VA and do whatever they tell you to do, because you're doing well.
And he is, Your Honor. He has another mental health eval on the 5th.
Okay, y'all are submitted. You're going to go in a breakout room right now. You can leave from the breakout room if you wish.
Thank you so much. Thanks for giving us the time, Your Honor.
You bet.
Mr. Collins, are you ready?
No, I need to actually talk with the ADA again with Arthur. I have some new information for him.
Okay. Your Honor, most of these now need to speak with ADAs, so just wanted to let you know it'll be a while.
Why don't we take a break and let them talk to the ADAs?
Yes.
In the future, I admonish all the defense counsel, you're supposed to do all this stuff in advance, not the day of hearing. But we have plenty of time today, so it's not a big deal. Okay? So just let them go and do that, and I'll be standing by. I'm going to turn off the picture and keep listening. So when anybody's ready to proceed, I'll be back. How's that?
Okay, hold on. I'm putting people in there. Hold on. I have to find you. Okay, Arthur, where are you? Hold on, hold a minute. Arthur, go back into 2 and I'll put Mr. Collins in 2 with you. Eddie, go back into 1. I think Mr. Ross is going into 1. He was the first one to ask. Mr. Ross, are you there? Okay, he's not there. Then I'm going to go ahead and put Mr. Fenari in.
Thank you, Pat.
Let me find where you are. Okay. All right, go into 1 with Eddie.
Yes, ma'am. Thank you.
Okay. Okay.